and Stressman. Both parties are present while Miss Coriano is on Zoom. Mr. Stressman is here in the courtroom. This is father's child support motion. Does he now has child care expenses? The parties had deviated down to 0 back in April of 2022. So nobody's paying support, as I understand it. Is that correct, sir?
Yes, sir.
What do you want to say then, sir? Yep.
Hello, thank you for your time. I'm here today asking for the court to review our order and requesting child support to be put in place to assist with the cost of living and child care, as it was not requested in the original order.
Who has primary,
I do. Yeah.
how many overnights does she have?
She gets them every Monday at 8 a.m. till the following day, Tuesday at 6 p.m. So 1 overnight. And then she gets them every Saturday, 8 a.m. till that Tuesday. So Saturday overnight, Sunday overnight, Monday overnight.
I get 104 overnights.
Okay. Yeah, it says here in the order, 104 overnights. And the last order from, as I say, April of 2022, about a year and a half ago, has a deviation amount that you guys agreed to. And as I understand it, the parties are working together to maximize their care, financial, otherwise, for the minor child. Both agree to the Michigan Child Support does not take into consideration this cooperation. Further, plaintiff earns $5 an hour plus tips in her new job that a long time ago. It is heavily impacted by COVID, and defendant is currently unemployed. Accordingly, neither has a reliable historical income basis for calculating child support under the child support formula. And both of you agreed to set it at 0. It appears that both of you don't agree to set it at 0. So why shouldn't I just send this to the friend of the court and see what they see as appropriate, ma'am?
Is she expecting her attorney Kelly Lambert?
Are you expecting Kelly Lambert?
Yeah.
Oh, you are?
Yeah.
Bring him in. I seen him in here. He just.
Sorry. He just logged in and I didn't
Oh, no
realize.
worries.
I didn't realize it.
It's not a big deal.
Yes, it is, because if you got an attorney, I need to have him here. All right. Mr. Lambert, good morning.
Good morning, Your Honor. How are you today?
Good. And you?
Doing well, sir.
It appears that we started not realizing that you were going to be here for Miss Coriano. And so my clerk just noticed you were there and we asked, and so basically all I've said is that there was an order back on April of 22 that had a deviation down to 0 due to various things. And I don't know that that is appropriate anymore. My thought is to send this to the friend of the court to see what is appropriate. Do you have any thoughts on that?
I discussed the matter with my client. We did discuss that the deviation reasons do not appear to stand to this day. So we're not opposed to a review for support to determine what is appropriate. My client's only real concern is she just wants it known that he did not get a babysitter so that she could work. What actually happened was she began babysitting for him because of his work schedule. And then after a while, she said, hey, look, I've got to go back to work myself. I can't keep babysitting for you. So I need to work. So that's her main concern, actually. I did explain to her that this would probably go to front of the court because of the deviation factors apparently not being appropriate anymore. The contact with Jesus Garcia, I don't think it's in the motion, but this is a motion regarding support. So I don't know if that's really relevant, but because it's not a support issue, but nonetheless, do I need to address that? Is that relevant or not for today's purposes?
I was gonna hold on a minute on that. Okay.
All right.
Mr. Stressman, it's my intent to send it to the friend of the court. They will take a look at your income, her income, overnights, whatever else is appropriate. They'll make a recommendation regarding child support. They will contact both you and her to send in financial information. If there is daycare, you have to follow their, sorry, didn't know I had a phone that was ringing. And you'll have to meet their standards for it, okay? I mean, you'll have to show that there is, and I don't know who, I mean, if you take it to Apple Tree or something like that, you'll have receipts and stuff like that. If you're saying your aunt's doing it, then the YMCA, so you are paying the YMCA, and you'll have receipts for that and stuff. And that, but make sure you'll have to show that on them, okay? So that is going to be I think the appropriate thing is to send it to the friend of the court, because they'll look at both and then they'll make a recommendation. If either of you disagree with what the recommendation is, you gotta file within 21 days and make sure otherwise the court will enter it, okay? All right, so that takes care of all that. I don't know what this is regarding child support when it says contact with Jesus Garcia. My son is to not have any contact with this man, and my son has informed me that he has talked with him while the mother's daughter is talking with him on a mobile device. Tell your son he's not to have. He shouldn't do it. I mean, he's obviously talking to the guy on the phone. All right, well,
He's not, Your Honor. This child is 3 years old. Jesus Garcia lives in New York. He is the father of my client's other child. And what has happened is he's called and talked to the other child. The other child knows, hey, my sister's talking to her daddy. And that's what's gotten back. But the child is actually not talking to this gentleman. And my client has even had her other child leave the room, so we don't have this confusion. It's a 3-year-old. A 3-year-old is not.
I didn't realize the child was 3, and he's to have no contact. Obviously, more important is the physical contact, which he doesn't have, and do what you can to keep the child away. But I don't know that there's anything more that I would do as a 3-year-old talking with his sisters.
6 days out of the week, you would be able to keep it away from you.
Well, yeah, and I'm sure Mr. Lambert, from what I can tell, Mr. Lambert's already said, keep the child away, and they do the best they can. I don't know. I don't know what the situation is, and how old's the other child?
6, 7.
6. I mean, these are 2 little kids that are difficult. Keep the child away from.
Yeah. And my client does that. We just don't know all the time when he's going to call. Sometimes they're in the car together, that type of thing. And of course, the child knows that my sister's talking to her daddy, and that gets back to that gets back to Mr. Stressman. And then of course it's twisted, and the child's not having contact with this gentleman.
All right. The parties need to work something together. I'm not going to micromanage this point to the point that says, if she's talking to her dad and this 3-year-old walks in and stuff like that, do the best you can. Come on, you guys are.
Back to the support. Originally, I had requested child support and sent to the friend of the court. I sent an email and they told me that I had to file a motion with you.
Well, that's
when was that?
Well, and I'm sending it to the friend of the court. We will refer it to the friend of the court. They will do an evaluation of it and come up with what is appropriate.
Okay.
All right. Anything else?
Nothing further, Your Honor.
We'll do the order of reference, so nobody has to file anything. Okay.
Is there cost allocation?
There, child support does not require cost.
All right. Thank you, Your Honor.
All right. Good luck, everybody. Thank you.
All right.
Thank you. I appreciate you.
Thank you. I can't see if you could put on your video, that would be helpful. This is a motion made by Mr. Dalton, the defendant, motion regarding child support. Says he's paying $1,000 for 3 kids, and now it's gone up to $1,200 for 3 kids. The FOC recommendation from 725. So there's no, from what I see here, there's no change of circumstance to allow modification. And from what, I don't know why your child support has gone up to $1,200, because it wasn't modified in this case.
Right, correct.
And so, it must be other children that it went up, and maybe you have an argument in that, but this case, they figured it out based on your income. There's no objection to income or anything like that. There's just your objection to say, I want to only pay $150 a month instead of $371 or something like that. But we didn't raise it in this case.
Correct.
There's no deviation that would come into play to lower it in this case. I don't know what your other cases are, and I don't know whether those are appropriately taken care of or what.
Well, may I speak?
Yep.
The Zoom that I had a couple weeks ago, in one of my cases, the mom kept the child support the way it was. She didn't object to them just keeping it the way it was. So that went back to the $160 a month that I was paying for that child. It stays like that. And there's another case, and I don't know if that's going to be on Zoom or not, but in this case, I've been paying $371 a month, and I've been doing what the court asked me to do. Plus I pay my daughter's insurance, and by my job, my job is slowing down. I think 371 is, it's becoming to be a little bit excessive. I mean, I don't mind paying my child support, the insurance, none of that, but I mean, $371, and it's like, I can't even miss 2 hours from work because I see it on my check. And I just want the court to maybe consider on lowering it for Ms. Brewer just a little bit, so.
I'm going to say, I mean, it's not that I don't have sympathy, but the child support is calculated through income overnights. You are given credit for making the insurance payments. Okay. You're given credit for it. And it's all, and in order, I can't just say, gee, let's give him a break, because there is no deviation factor. I'm left with, the amount is appropriate. Therefore, you have to have a deviation factor to go lower, and it isn't met. There is no deviation factor for I'd like a little bit less because it's really taxing on me. There is none. And so I'm left with no ability to lower it just because I happen to like you and think, it's tough on you. Ms. Brewer, do you have any thoughts? You don't have to have any.
Yeah, I do.
All right. It's just something that is set by the state. I don't even calculate it. I mean, these numbers go in, the front of the court calculates it and says, this is what it is. And there has to be a valid deviation factor. And there are like 25 of them, but they're not just because things are difficult. So I'm left with the idea that I cannot just lower it. You guys can agree to things, but I cannot lower it just by saying it makes it difficult for you.
So I'm just stuck with, paying the almost $400 a month plus insurance for my daughter. I mean, which I don't.
And
I
I
haven't
understand that the premium fees that you pay.
And my daughter's 10. I haven't argued with that in years. It's just sometimes, and I understand your position. Sometimes, I mean, I can't afford it. If I get sick at work, I bring home no paycheck, and I live alone. I don't live with nobody. And it's it's hard for everybody. I understand that, but I mean, I haven't argued with this. This is the first time I ever argued with this $371 a month. This is the first time, and I've been paying it faithfully. And, I haven't argued, like I said, and I just think, yeah, do I deserve a little break? Yeah, I do. I'm not trying to take away from Ms. Brewer and my daughter, but, I have to live too in order to pay this money. And I haven't argued with that in years. And I've been paying it faithfully, every week.
All right, and I listened and I said, I'm just not able to lower it.
Okay, I understand.
I'm not able to, and I might agree with stuff or not. I mean, I don't know what your financial situation is. I know what you tell me it is, but quite frankly, it's what the state says you have to pay, and I can't change it without a deviation factor, which is not met. So I can't go outside the law to do something.
I understand.
All right. Thank you all very much. I'll have to deny your motion respectfully and appreciate it. Thank you. 50-DS. Both parties are present via Zoom. This is regarding their 15-year-old daughter. This is mother's motion, the plaintiff's motion to suspend the father's parenting time. She cites two incidents, one on Labor Day where the daughter called and said dad was yelling and swearing, and it scared her. And on November 12th, the daughter called and said dad was yelling and swearing at his wife. And dad came in the room apparently to take her home, and she didn't want to go because, I don't know, she was scared or something. And mom went there and dad was being arrested. The only those two incidents don't come anywhere near allowing me to suspend his parenting time unless there is something from this arrest. What were you arrested for, sir?
I was charged with domestic violence and resisting arrest.
You were charged
I
with
do have
domestic
the-
violence?
I'm sorry, what did you say?
Said you were charged with domestic violence?
Yes,
Where is that charge? Out of what court?
Berry County.
And it's a pending case?
Correct.
All right, that's a little bit more serious than just some yelling and swearing. Ma'am, what do you want to say?
I apologize. I was gonna say that I have the police report if you would like a copy of it. But that was all I was gonna mention.
I don't know how I'd get it now.
I just got it the other day.
All right. Sir, are there any restrictions on you? Anything from the charge? What are the bond conditions? All this kind of stuff.
The only current bond condition that I have is that I'm not to have contact with my wife at the moment. But I'm currently working on getting that conditions.
Well, how do you live at the home then?
I haven't been. Due to the nature of these charges, I've been forced out of my own.
Well, I understand it, and if you committed domestic violence, that's the cost you pay. But so where are you even going to visit with your daughter now? It sounds like you're a little bit out of control to me. But go ahead.
Well, I would like to first state that these are allegations.
I understand.
I have these charges disproved and dropped.
I understand.
But it is also worth stating that I'm currently staying with my sister in Kentwood, and that any kind of visitation, even if it was supervised, would still be acceptable. I just don't think that this is really the kind of situation that's necessary to suspend my parenting rights.
I already said that I didn't think it was necessary to completely suspend it, but ma'am, do you know where he's living? Do you know the sister and stuff like this?
I'm aware of the sister. I do know where he is living. I know that the sister and the brother-in-law are both having issues with alcohol and opiate use. As when I went to serve them, they were out for an NA meeting. And according to our custody paperwork, he has to have a bed for Paige if she is to visit him overnight, which I'm not sure that is the case.
Is it the case, sir?
Absolutely not. There's no opiate use whatsoever.
No,
My brother-in-law currently
I know
has
you're going to deny that. I understand that. I'm saying the bed issue.
the what?
Does Paige have her own bed when she goes there?
She would not have her own bed here, so doing overnights would be difficult. But that's something that I can have arranged, so I can have it.
When is your next hearing on the domestic violence?
My first PCC will be on January 3rd.
I mean, you got to understand that the court looks really seriously at domestic violence. It's one of the main it's one of the factors in child custody and everything. I can go through this and read it to you, but factor number K in custody, domestic violence, regardless of whether the violence was directed against or witnessed by the child. Obviously, she witnessed some of this domestic violence.
I would say that she definitely did not witness that violence. That all she heard was.
What?
It's a complicated situation. I was coming off of medication that had drove me into a manic state. And although it was an unfortunate event, no violence actually took place. Those are just simply allegations, and I intend to have them disproved.
All right. Do you have an attorney in that case?
I do. His name is Cranky Stanley.
Frank Stanley?
Yes, sir.
I know Frank Stanley. Very good attorney. Very unfortunate event.
He's a good man. He recently lost his granddaughter.
I know of that too, and that's gonna put a crimp and stuff, but all right.
I also have a letter from Paige we were going to present to you this morning.
I don't listen to the kids' statements because it's too
Okay.
I don't read letters from kids and stuff like that. It's over the years you learn that sometimes parents stand there and say, write this to the judge, okay? And I don't know what it is. And it just is it's not appropriate to read what she has. I think what is his parenting time right now? Every other weekend or what?
It was every other weekend, correct?
Well, I I think maybe, instead of every other weekend, he could visit every other weekend on Saturday from 10 o'clock till 6 o'clock and Sunday, 10 o'clock till 6 o'clock. He admits that there isn't a bed there right now for her, shouldn't be overnight. And we can do that for a little while and see what happens to the domestic violence charge. And sir, I mean, you got to understand that I was a criminal defense attorney for 35 years with Frank Stanley, and I know who he is. Okay. But there is a difference in proof. All right. Proof of beyond a reasonable doubt of domestic violence is one thing, but that is not nearly as high a proof as it is for some type of parenting time change and stuff like that. Okay. It just isn't the same level, and it can be clear and convincing or a preponderance, and those are less. So I think for right now, I would, ma'am, how far away is he from you? I mean, is it, I don't know where he was living down in Berry County. Is it, how far
With
away
where
from
I'm
you?
staying in relation to her address, I would be considered about within 5 miles or less of her current residence.
All right, ma'am, I'll entertain anything you want to say. My thought is right now, I'm not going to suspend his parenting time at this point because I'm not sure that it's appropriate, but I am going to cut it down some until things get resolved. And I don't see why he couldn't have several hours on a Saturday and several hours on a Sunday on his every other week instead of this overnight thing.
Paige and I were both curious if that could be supervised. She is weary about being around him.
Yeah, well, by who?
My parents,
I'm
they
sure,
live within 3 miles of my house.
I'm sure that's really uncomfortable. I can't imagine that he wants to spend 8 hours on Saturday and Sunday at your parents unless he doesn't have any problem with it. But your thoughts, sir?
Well, I would say that I'd be willing to be amenable to the situation. However, being forced to have to spend those 8 hours there every other weekend could potentially be a problem. Only in the respect that it would be useful to be able to take her places. So I suppose if a supervised visitation was set for a specific time and that there was clear communication as to where we were, and that there were clear boundaries as opposed to where not to go, that would be more than acceptable. I understand the situation is not ideal, but I am still Paige's father and I intend to continue to be so.
I intend to allow you to be her father. Okay. There's been a setback, but we'll deal with it. Ma'am, I'm just trying to work out something decent here. He's even saying he'd go to your parents to be with her. But I mean, do you have a problem if they go out to the mall or to lunch or something like that during his parenting time?
I don't mind them going to a public place.
Yeah. Which is what, I mean, I think that would be appropriate, sir. If you want to go to a public place with her, not necessarily, I don't want you going back to your sisters or something like that. If you're going out and doing some fun stuff, which probably right now is the most important thing for you, is to do some fun stuff because your daughter is a little bit afraid and you got to build up that trust again. All right.
I completely agree.
So we do every other weekend from Saturday at 10 till Saturday at 8.
You originally mentioned 6.
Oh, that's what I meant that. I was going to say 8 hours, but
10 to 6, that's doable.
6 and same on Sunday. And that also would include the parenting time would take place supervised by who? I don't know their names.
Oh, I'm sorry. Diane and Lee.
Yeah, I mean, they don't have to both be there. Bosma. And ma'am, you're gonna have to talk to them because clearly they're gonna and they are, I don't want any pushback or anything from them against the father, okay?
No, and they're aware of the situation and I have mentioned it before and they are completely willing to have something.
Well, I mean, I don't want them treating them anything other than
Nope,
good and all that
absolutely.
stuff. And if they're making sandwiches on Saturday at noon, I don't want them to make them for everyone but him.
Correct.
that kind of stuff. All right, I just want this treated correct, okay? Diane Lee Bilesma, dad can take child to public places during his parenting time. Okay, he can take him to places, public places. I'm going to tell you both that this is surprisingly easy to figure this out because both people seem to be adults in this matter. Mr. Crashbauer, you know that whether he did, I don't know whether he did it or not. I'm not saying it because you're presumed innocent, and I know that as well as I know anything. All right, but the two of you can also start to talk some about this and try and reach some kind of agreements, especially as it relates to Paige and how she's dealing with this and things, and maybe you can, since his parenting time is somewhat limited, maybe you guys can agree that one night a week he'll pick her up and take her out to dinner and bring her right back or something. This is the kind of stuff to rebuild the relationship with the father. You don't have to, I'm not putting it in an order, but that's the kind of stuff that helps, okay? Because your daughter has to learn, for whatever reason, to trust them again, all right? And maybe it was just the medications, and she'll see that after a while that things are better. All that'd be great. But I do want you to, you appear to be, unlike some of the people who show up and will show up today, you appear to be adults. And so I hope that you can discuss it some, not being in a relationship, but you are the parents of this child. Okay. So I'm just suggesting that, and you can come back on a motion to reinstate the parenting time if all this goes away or whatever. You might also want to consider, does Paige want, would she be acceptable to maybe some kind of counseling?
She's seeing a therapist at this time. She's been seeing a therapist due to issues at her dad's house.
All right. Does he know who the therapist is?
I do not.
He should. All right. I'm assuming you have joint legal custody.
No, I have full legal.
Full legal?
Correct.
All right. Well, in order to try and reach some kind of, it would be nice if he knew who the therapist was, and maybe could even contact the therapist so that he can try and help too. You got, and sir, I mean, you better be appropriate. That's all I got to say.
I 100% agree with you, and I couldn't agree more, really. That level of communication would be extremely desirable, actually. I would find that incredibly, not only amenable, but just like understandable.
Do you ma'am, I mean, I don't want to make an order that you tell him who the therapist is, but I think you should.
And that's fine. He's never asked, and I don't divulge, so I know that some of that is on me as well.
Yeah, like I say, you both seem pretty decent people here, and so talk to him about it, and maybe he can talk to the therapist, because maybe the therapist can give him some ideas of what he needs to change. Okay, and you got to listen to it, sir. So let's see what we do. This will be the order of the court for the time being. When things work out some way or another, we may come back and change it at some point. All right. Any questions, ma'am? We'll enter the order. I don't know when. Is there also something going to happen on Christmas where he sees his daughter at your parents' or something like that?
His holiday is Christmas Eve this year, and he's more than willing, or more than okay, to see her at my parents'.
All right. Talk to him and figure out, even if it's a few hours, you can have that over at her parents', and it'd certainly be nice if you could see her at Christmas Eve. All right.
Even just a few hours would be wonderful, given my current circumstances.
Please make sure that happens. Is this supposed to be his weekend or next weekend? Or do we know?
Next. I apologize.
I believe, just for the sake of everything, that we should probably start with next weekend, unless that is not doable.
Yeah, well,
Next weekend, I believe, is his supposed weekend. So
okay, so start it next weekend, and I believe next Sunday is Christmas Eve.
Correct.
So you could see that, then take care of everything at once. All right.
Sounds good.
Everybody, I'll send out the order. It will go out and it'll take some time. I don't know where to send it to you, sir, and I don't really want you to give me an address because we're on YouTube and I don't need everybody to know where you're living. But maybe you can contact my clerk. Can you email my clerk? You have her
I can do that.
at tracy.dewey@kentcountymi.gov. You can.
Sure.
You probably already sent him something.
Yep, I've already seen an email from her already, so I'll just go
Right.
ahead and respond.
If
to
you
her.
if you could send her so that we can get that order to you. All right.
Thank you.
Everybody, good luck and
I
a
just can't
nice
see
holiday
you. You
season.
can't-
Thank you. I can't see
I
you
can see
either.
you as well.
Okay, well,
There.
can we, it's probably for the best. Can we make this work?
For right now, we can. All right, this is the matter of Caston versus Flores. This is the defendant, Ms. Flores, is present with her attorney, Joel Helder. On Zoom, the plaintiff has not shown up. This is the motion, ROPA motion, if you will, to eliminate a child from the divorce that was just recently born. When the child born in October or something?
Yes, that's correct.
And Mr. Helder has submitted to the court a DNA sample, actually showing the father that they claim is the father, not necessarily Mr. Castron hasn't been eliminated, but we do have a 99.9999% that a different gentleman is going to be the father. Now, isn't that only one of 3 kids in this marriage? Aren't there?
Yes, that's correct.
All right, so I will, if you want to submit an order that says that child is born out of wedlock, that is fine. I will grant your motion for that, Mr. Helder. I know you wanted to enter the judgment of divorce, but quite frankly, the notice that you have did not ask for that. And the notice that would have been sent to the plaintiff did not indicate that you were going to be entering the judgment today. It just says, quite frankly, a motion to revoke paternity will be brought. And so, unfortunately, I'm going to ask you to notice a pro-con hearing with any of us in the near future to enter the judgment of divorce, but we can enter the order that finds that one child is not a party of the marriage.
Referee, that is all fine and good. That was kind of our direction from Judge Hillary, was to schedule this motion and get that issue out of the way and then enter the judgment consistent with the relief granted at the trial. So I will notice that out. I wonder if I am able to do that under the 7-day rule, or do we need to take proofs?
We'll need to take proofs.
We need to take proofs. Okay, then I will notice that out for a pro-con.
Yeah, and we do them all week and stuff like that, and you don't have to notice it on for me. You can, but it doesn't have to be on my slot, even though it's Judge Hillary's case. Anybody can take a pro-con.
I understand. Thank you so much.
Right? But make sure he has proper notice of it, and then we have no problem entering it. All right?
That's great. Thank you very much.
I hope you feel better. I don't know what you got, but
a little bit of this, a little bit of that. I think just not feeling great today.
hope you get better by next week, so you can enjoy the holidays. So if you want to send the order through of the child not being a party of this marriage, that's fine. And notice that out. We'll get this all taken care of in the near future.
That's great. Thank you for your time.
Thank you. Thank you, ma'am. I know you didn't have to say anything, but thank you for being here. It's a matter of everybody have a nice Courtright versus, and I'm not sure how I pronounce your name, ma'am.
Heike.
Heike, okay.
Yes.
This is, both parties are present via Zoom. This is the defendant mother's parenting time request. She says she wants to get her during the week for school. Basically, they change some stuff during the week. I think there's alternate weekends. Dad gets like Tuesday overnights to Wednesday and Thursday to Friday maybe, or whatever. There is some switching during the week, and mother's motion says she just wants during the week and give him every other weekend in effect. Is that correct, ma'am?
Yes. Just because of everything that's been happening over the past couple years, a lot has changed, and I just would like to have her, if possible, during the week.
Sir, does he get her to school?
Yes, I believe his mom brings her and everything during the school. It's just my concern is the environment over there and just him traveling back and forth from Michigan to Ohio because his girlfriend lives there with his newborn.
All right, sir, what do you have to say?
So I only travel on Sundays, and Mariah, she's only been with me once or twice, and I go every Sunday.
And
So
you have Mariah on Sundays?
so the Sundays that she brings her to church, if I know that like I'm not gonna be back in time, I always ask Lexi if she wants to keep Mariah for that day because I know that she would like more time with this just that Sunday, which I'm fine with that. But it's not like sometimes like I won't go on a Sunday because she'll be able to come here on her own. So like I'll keep Mariah on my Sundays.
So you can do the current parenting time schedule and get your daughter to school on time and everything like that, even if it.
100%.
All right,
I
and
mean, since she's been with me, she's never missed a day of school. She's never been late. I mean, she's always been on time to get breakfast and get there, you know, whenever she needs to get there.
it appears that do you live with your parents there?
Yeah, so I live with my
And
parents.
you're allowed to live with your parents. I'm not just
Right.
Does your daughter have an appropriate place to stay and sleep and stuff like that?
Yes, she shares a room with her sister, but she does have her own bed. She has her own dressers, her own clothes, everything.
All right, ma'am. So what is the reason to change this when I don't, it's just kind of like if it's not broke, don't fix it. It doesn't appear that your daughter's in any danger.
But just my concern is they have a 3-bedroom mobile home and he lives with his parents, but his brother also lives there with his kid. And when Mariah's there, it's her and her sister, but then when her dad's girlfriend comes, then the baby's there. It's just, I feel like it's just a lot of people living in just a 3-bedroom trailer. And he lives out in Wayland. So I live a lot closer to her school. I live 10 minutes from her school. And it's just, my environment is a lot spacious for her. We have 2 dogs, but it's just, she has her own room. Obviously I don't have another child, so she doesn't have to deal with any more siblings in the house. But that was just my concern, and just my opinion is just a lot of back and forth, I guess, during the week. Obviously she gets to school perfectly fine. It's just, those are my concerns. It's just the environment where she's living with him, just how many people are in the home, and just her going back and forth a lot during the week. And I know we did this schedule back in 2017 and I tried changing it, I believe, back in 2020. I know she's told me several times that it is a lot going back and forth, and I don't really know what to say to her about it because it's with the court. So I just,
I would imagine it started out with you guys agreeing to this way back, or else there was a court order, and it was put into a court order. And I don't change parenting time because one house has more kids in it than the other, or is more crowded. It sounds like your daughter's taken care of. It sounds like she is taken to school. There's nothing here that sounds like it's a problem for your daughter. If you and Mr. Courtwright want to talk about maybe not as much back and forth, but maintaining the same amount of time, maybe 2 nights in a row as opposed to one here and one there or something, that's fine. But at this point, I don't find anything that would necessarily lead to a change in parenting time.
May I add something?
Well, go ahead. Go ahead.
For several times, and I have that in text message, I have asked Mariah's mother, Lexington, if I can do 50-50, week on, week off. Because with my youngest daughter, that's the schedule I do with her, and it's working perfectly fine.
I understand that's your request, but that's a change of custody. And you gotta meet a pretty high standard. If the two of you wanna agree on it, you guys can agree on almost anything. You understand that? I'm not gonna stop that one way or another. But if she doesn't want to, that's another 40 overnights basically, and she is under no obligation to do it. You can file a motion for it, but it's unlikely it will go through just because you have to meet a pretty high standard, proper cause or change of circumstance. Just like she does, if she wants to eliminate much of your parenting time, she would have to do that. As far as modifying it to say, okay, he gets Monday overnight and Thursday overnight, and I'd like to give him Monday and Tuesday overnight because of this, and this, that would be in a lesser standard for proper cause or change of circumstance. But at this point, that's up to the two of you. I would hope that you would continue to work on things and that you will both be parents that will take your child into consideration. You apparently do. I don't find anything that dad's doing to be bad. So as a result, I would not change the parenting time at this time. Anything else, ma'am, you want to put on the record?
Is there any way we can at least, because obviously I have her Monday nights and then she goes over there Tuesday nights and then I get her back Wednesday and then she goes back over there Thursday. Is there any way I can have her Tuesday fully if possible? So it's not like a back and forth every other day. I didn't know if that was like a possibility.
So you're saying you'd want Monday and Tuesday and give him Wednesday and Thursday?
Well, no, I would take his Tuesday. But I didn't know if, because it's just a lot of, I guess every other day is what I'm getting at.
Yeah, but why would you take his Tuesday without giving him something back?
I'm not sure. I was just trying to eliminate.
That's what I'm saying. You can talk to him and try and figure something out, but but that's up to you. At this point, I don't think you've met the standard for a change of parenting time, and you're stuck with what you got for this period of time. I hope the two of you talk and work on stuff, okay? And it sounds like Mr. Courtwright does sometimes say, hey, if I'm gonna go down there and whatever, and you can keep her for Sunday or something like that, you should always work together on things like that and whatever. But I don't find that you've met the level of standard for even shade, that nothing you know about, but to modify parenting time at this time, especially when you're trying to take his Tuesday, which would be what he gets every Tuesday?
Yes.
Overnight?
Yes.
That'd be taking 52 nights away from him, and that would be a change of custody. And you don't meet proper cause or change of circumstance for that. So good luck, everybody. I'm going to respectfully deny your motion. I hope the two of you will always work together to try and figure some stuff out in the best interest of Mariah. But good luck. Thank you, and have a nice holiday season. Versus Payne, the plaintiff, Mr. Pegg, is present with his attorney, Mr. Jansma. The defendant is not. My clerk said there's something that you've been trying to get her to log in or something.
Well, yeah, there's been communication with her. I think she was confused and thought the hearing was in person this morning. So my client let her know that it's via Zoom and gave her a link to log in and get on the hearing, but she thought it was all a trick and wouldn't do it. So I don't know if the court wants me to get into the issues or if you want me to adjourn this out a couple weeks so she can appear on the hearing.
I understand the only request is for genetic testing.
Well, that's the request. They've already done a DNA test, and my client is 99% certain that he's the father.
That's all this is noticed for. So
yeah, I know this was filed by him, and we're at a point where she was giving him overnights and parenting time, and then she took it away. So I guess I can renotice this and file it properly for a request, a request for a temporary order and all of that.
Yeah, you're going to have to, because I can't go into that stuff.
Yeah.
Having not been noticed to her and her not being on to agree to something.
Yeah. So, all right, I'll go ahead and we'll just adjourn this, and then I'll file a proper motion and everything and reset it.
All right.
Okay.
That would be the best. All right.
All right. Thank you.
Thank you very much. Thank you, Mr. Pegg. Good luck. Have a nice holiday. Both parties are present via Zoom. This is father's objection to a friend of the court order that had just had just come out, looks like it was mailed 11/9. His objection was filed 11/27 within the 21 days. And what it was abatement of support. As it says, the payer is living with the child. Is that, sir, tell me what, I read your motion, and I'm kind of confused because there was a prior order that said she was paying you, and then it looks like the latest order talked like you were going to be paying her. The last one that came out, recommendation, was back in February, and it said you were the payor and she was the payee. But it doesn't look like it was entered. Can you help me out on what's going on here? Do you have custody of the child?
Yes.
And the defendant has parenting time, I assume.
Yes.
And
She,
I mean, does she live with the child?
no. The child still lives with me.
Right.
She still exercises her parenting time, Wednesdays from 6 to 8:30, and every other weekend, Friday from 6 until Sunday, till 6.
All right. And some holiday time and stuff like that, I assume, but
Correct.
generally, ma'am, is that your understanding of?
This is for my 18-year-old who no longer lives with him and lives with me now. All I was trying to do is get that through court, that it was sent that I don't have to pay child support anymore for him. But I don't understand what he.
I understand your oldest son is 18, and I don't know if he's going to school or if there's any reason to extend it or anything like that.
Yeah.
This is really for your looks like 14-year-old daughter.
Yeah.
And so, but does your daughter live with you?
No, that I'm still paying. I was going to continue paying for her, but all I did was file a motion for my son to be, he lives with me now. He's going to school with me. He's 18, and then child support was supposed to discontinue as far as that. And then he filed a motion stating that my daughter still lives with him, which is true, yes, but I don't understand what the objection is for this with him.
On the motion that she filed, it said that both of them lived with her. So I filed an objection because our youngest daughter still lives with me.
No, I did not say that no, it was just for JJ, for Jabari. He's turned 18. Of course, I'm not going to do that because she's still with you and she's only 14. I would not do that. Of course, I'm going to continue paying for her. She's still with you and she's 14. But the only thing was just for JJ because he turned 18 and living with me and going to school. And I sent all the information to the court.
It appears then that your child support should drop down from 2 children to 1 child.
Yes, sir.
And I'm not sure what the latest order was, but it looks like about $512.
Yeah, I'm paying $800 for both.
And you should make sure that you inform the friend of the court, both of you, that your oldest son is no longer eligible for child support.
And I did that. I gave all the information to me, and that's when Mr. Joseph had 21 days to object, and this is what he sent to me.
But it says on the order, the change is effective and it redirects with regard to the following children, and it says both children.
I don't understand why it said that.
As if both children live with you.
No, I didn't file anything about Anissa. About the 14-year-old, no.
All right.
It was just for my oldest son. That's just, yeah, I know that. It's obvious. She's 14, he's 18.
All right. So what I need to do is set aside that order that changes the support and says both children live with you, and make it that you only now, since the oldest child is 18 and the youngest child is still on child support with the father, that child support is payable only for the youngest child.
Yeah, I don't know how that got mixed up. I don't
know how they got it mixed up either, but I was kind of mixed up with it when I was reading it. So.
Oh, okay.
So, Mr. Joseph, that's what you want, right?
Correct. Yes.
I'll see what I can do to fix it. All right, that we'll make it so that I believe it's like $500 a month for your daughter. And the other child should come off child support, right?
Well, right now I'm paying 800 for both, so I don't know how that works, but yes.
That's 800 for both, but that child needs to stop because that child's
Okay.
18, all right? So let me see what I can do as far as a court order to fix that. If we're having additional problems, I'll probably have my clerk contact you about it, all right? If you need to do anything with a friend of the court, I'm gonna contact a friend of the court to change this the best that I can.
Okay, sorry for the mix up.
And grant his motion to set aside the friend of the court abatement order. All right.
Okay.
Good luck. Have fun. I hope you have a great holiday season, and hope we can take care of this in the next week or two. All right.
Thanks. You too.
Thank you. Matter of, it's now Mrs. Willett. And her attorney is Mr. Christensen. He's present. Mr. Hernandez, we hope, will be joining us through the internet any moment here now. And his attorney, Miss Maltby, is present for him. We kind of got to wait for him to get in here. This is the father's parenting time request. Looks like child's like 9 years old. And he's still out there somewhere? He's still stuck. One of the negatives of Zoom, because if you guys were here in the courtroom, he wouldn't be stuck between here and the hallway or something.
Gone, so he'll either
Oh.
stop in a minute or he'll log back in.
Well, we'll give him a second to log back in because I guess he's gone altogether now, but he was here, so we'll give him time to get back in. If he's not in shortly, I'll put you back in the wait. Oh, he's coming back in. Miss Maltby, you've hidden your client in the internet somewhere and
Yes, my area of expertise apparently this week.
let me tell you, there's nobody who's more of an expert on Zoom than anybody but me. I didn't have a clerk here. He's apparently still having some difficulties. I certainly don't want to proceed since I know he's trying to get in. I might put everybody back in for a minute, see if he can work on his stuff. We'll call another case and bring you back in. I don't know what else to do because he just can't seem to get in here. Miss Maltby, maybe you can talk to him, email him, whatever, and let's see if we can get it. I'll continue to work on trying to get him in, but I'm going to take another case in the meantime. So
Okay. Yeah, I'll reach out to him right away.
yeah. Let's see if he connects. Mr. Wickens isn't connected either. I'm assuming Miss Wickens is Miss Davidson. You can hear me, can't
Good
you?
morning. Yes, sir.
Well, the last case, we couldn't get somebody in and he all of a sudden popped in and Mr. Wickens is out.
I see a Moses Hernandez.
Pardon me?
I said, I see a Moses Hernandez.
Mr. Wickens, are you present? Can you hear me? I can't hear you because you're on mute.
Okay, I can hear you.
There's another person on my screen who's trying to log into the prior hearing. He was having a tough time and then all of a sudden he popped in. So if I find that, oops, he's connected, let me talk to him for a second first. Mr. Hernandez?
Oh, hello. Yeah.
All right. Mute yourself and sit there. We've taken another case in the meantime because you couldn't get on, but just mute yourself so we can take your case next.
Got it. Got it.
Wickens v. Wickens, both parties present via Zoom. This is a motion to enforce a judgment that Mr. Wickens says was supposed to be paid, and there's still $3,990 or something like that left. I understand Miss Wickens has contacted us and said she never got notice of the motion. Is that correct, ma'am?
That is correct. I came downtown after I got a text message Wednesday evening yesterday to just try and get a copy of it. They sent me to the clerk's office. The clerk's office said it had already been sent up. I emailed Tracy Dewey. She said she didn't have any more information other than a motion to enforce. So I don't even know what this is about.
Motion to enforce judgment. Sir, I'm sure you're going to say you mailed it to her. Is that correct?
It was put in the mailbox on It was on 12/5, the day I filed this. And our mail people dropped off the mail to our house that day. It didn't go to our mailbox, so it didn't go out to the following day. So it should be at her house by now. She lives a block away. And this is the exact same thing she's seen
Wait a
before.
minute. So you're saying well, I understand, but this is also not horribly urgent. This is a motion to enforce. And,
I understand if we need to reschedule.
ma'am, it's either we're gonna bring you back in 2 weeks or we're gonna deal with it. He just says you haven't made all the payments that you were supposed to make on that judgment from a long time ago, and they still owe close to $4,000 and it's way past due.
I have. I've made it in full. I contacted 2 different banks regarding the interest. I remember back in February, he told me that Tracy Dewey emailed him how the interest was to work, a percentage, which is opposite of what the 2 different banks I contacted said. So this has been in a stale conversation since last February. But I have all the information.
There is no way, Mr. Wickens, if you're telling her that, there's no way Miss Dewey told you how the interest works. She doesn't give that.
Miss Dewey told me where to find the interest. I found the interest, and in one of my prior motions, I sent how I found that. The court-appointed interest was 3.671. It is whatever. There was a period of time where you made the motion that she owed me the money. It goes based on the interest rate plus 1%. 3.671 is exactly what it is.
But it's hard for me to believe that there's $4,000 left just based on interest.
It's not just based on interest. It's based on her payments throughout. I've kept good records of this. This is exactly what she's paid and what she still owes. And she took well over, it's been over 2 years late. It's been forever. She requested to take longer to pay this, and I allowed it because I didn't want to fight in court anymore. I'm tired of going to court. And then after the 2 years or another year, she paid me a final amount that was still several $1,000s short. So I've been trying to file this. This is my 4th time, and
see, the last payment apparently by her was $9,495 back in February of this year. Is that correct?
Correct. And at that date, she owed $3,800 still.
And it shows through the balance of everything here that it shows that she still owed $3,870.41 with your calculations. So, ma'am, I assume you dispute that no matter whether we have a motion here today or have it in 2 weeks. You dispute that you owe money, right?
Yes, I do, because the interest, when I had the bank pull as of 7/20, it's a moving interest rate was 0.699%. Adding in the 1 is 1.699. So he was paid in full according to what I was told. And if Tracy emailed him how the interest rate works, then I would like to believe that the court would copy me on that also.
It was a phone call. It was never an email. I spoke to her. Tracy
Dewey called you?
Hold on. Hold on a minute. Stop, both of you.
He contacted me and asked if I could let him know what the interest rates were. I said, I don't know. I said, go to Michigan or whatever it is and look on there.
You told him to go to michigangovernment.com and look up the interest rate. She didn't know the interest rate. She wouldn't know I don't know the interest rates. So she didn't tell her what the interest rate was, told him where to go to look up for judgment interest, I'm assuming, correct?
Correct.
And that's where I went as well.
And that's what?
That's where I went as well, just by Googling it. And the interest rate in July of 2020 was 0.699. And then it also says that a 1% is added. So the interest rate then would be 1.699.
And then what was it as the time went on? Did it increase? Because you looked in 2020, but you didn't pay it off till 2023.
From what I was understanding, from what I read on that website, that it was whatever that interest was, according to that 2-month period, it stayed that interest rate through the entire time. And you could go and look right now at that record. It says 2.671%. And I have a screenshot of it, and I should have put that with this. I apologize for not. I can get that to you, but it can be looked up online right now.
I would like the opportunity to submit my records.
And you got that interest rate as of 9/1/20. Is that what your interest rate is, you're saying?
It was based on the date that the
date the judgment was in.
Which was on 2/19/2020. That's when it should be based on. That's when the judgment happened.
All right. Well, she claims she doesn't have this kind of stuff. I'll set you up, you guys, for an in-person for about 30 minutes at some time in the near future. I'm not gonna make you, ma'am, defend it if you say you didn't get interest, but obviously we're just gonna have to do something on it because he claims, yeah, and I haven't looked back to see what the interest rate is, but he claims it's 3.671. I don't know where you got yours from. You say you got yours from a bank? Ma'am?
No, I had banked do the calculation of how the interest worked. The interest rate that I had was 1.699. So I had Hastings Bank and I had Fifth Third Bank figure out the interest of the total amount each month.
I'm pretty sure that I can probably look back and see what the interest rate was as of the time of that it became interest bearing. And if your interest rate's off, well, your interest rate's off. If his is off.
That's fine. Yeah.
Anything else anybody wants to say? We'll set you up to come in here for half hour to an hour to go through it.
Okay.
Okay.
And somehow got to make sure that she gets this paperwork that you filed.
I can hand deliver a copy. I still have my copy. That's not a problem at all. I absolutely mail it. It was one day later than it was supposed to, though, because the mail lady dropped off a package and didn't go to my mailbox.
If it was sent out on the 6th, it's still valid for the 15th. And you know, I don't know. It seems to me you would have gotten it, ma'am.
I would like to believe so as well.
But we'll set up just a real short hearing to go through this and look at the documents. Make sure she gets a copy of the documents, however you want. Can he drop them off in your mailbox, or how do you want it?
He can put it in my mailbox. He can make a copy of whatever he originally has. It's fine by me. I have no idea. Or he can email what he
I'll
turned in.
email
That's
it
perfectly fine as well.
minutes.
Yeah. Yep. And I will email back confirmed once I receive.
That would be wonderful. All right.
Yep. That way there's no questions. Okay. Thank you.
Thank you. See you in the near future. Have a happy holiday.
You too.
Thanks, you as well, sir.
All right, we're back with you right after we took the other case. Mr. Hernandez logged on and we just left him there muted while we did the other case. So we still got him. Now, if we get everybody else in, it'll be great. The parties are present with their respective attorneys. That's Mr. Christensen for the plaintiff, Ms. Maltby for the defendant. This is the defendant father's motion, basically saying that he did the best he could with the prior order, went to counseling. They wouldn't do anything with him, which was required, that he should have at least one session, and the counselor refused him. He's gone to supervised parenting time at Journeys, and I guess he continues to do that from August through now. One problem that there is that I've only got a Journeys report from back in August. I don't have any idea what's going on since then. But this is your motion. Mr. Maltby, what do you have to say?
Yes, Your Honor, thank you. And it is renoticed from a date earlier this year in which my client, in pro per, brought the concern before the court that plaintiff mother had refused his parenting time with their 9-year-old daughter. As you indicated, there were another number of things that were ordered after that May hearing, including that he attend counseling, that the daughter participate in counseling, and that the therapist provide a recommendation. Unfortunately, as the court indicated and was made aware, the therapist refused to provide a parenting time recommendation, as saying it's outside her scope, and also did not allow Mr. Hernandez to participate in that counseling, as she felt it would be detrimental to her relationship with the minor child. Another therapist was sought. Plaintiff mother did an intake through Pine Rest after opposing counsel and I were able to discuss the concern that this therapist isn't providing, a recommendation. It's unknown what happened in terms of that other therapist, or if any relationship was ever established. Mr. Hernandez has been participating in the weekly parenting time at Journeys, which is supervised. Journeys provided a report back a few months ago, as you indicated.
It was early August, and that's a really old report.
Yes, and he has participated weekly since without any concerns. Even the plaintiff's response has indicated that the minor child enjoys the time with her father. The therapist's report indicates, she also expresses she enjoys her time with her. There's been nothing to determine that there's any concern with the father specifically. If there is an underlying source of any behavioral changes that plaintiff mother may have noticed, it remains to still be unknown, even with months of therapy, and to continue parenting time as minimal as it is in an environment that is not ideal to continuing to build and foster their relationship, simply can't continue and is not necessary. Prior to the parenting time being withheld earlier this year, Mr. Hernandez was involved regularly in his daughter's life. They were exercising every other weekend during the school year, longer periods of time during school breaks, rotating holidays. He was intimately involved in her day-to-day, in her upbringing, in her care, and he was a regular.
I understand all that, and I understand that there was supposed to be some counselors' help, which counselors just don't seem to ever want to help anybody. They busy counseling and doing nothing to assist me, who does not know anybody involved in this, whether it be the parties or the child, and trying to get some idea. Let me ask Mr. Christensen what his thoughts are on this, because I mean, I can't keep ordering that he be involved in some kind of counseling, and they won't even allow him, or won't even give any assistance to the court, whether it's valuable or not, whether he's got a problem or not.
Well, I share your frustration, Your Honor. It is difficult to get any counselor to make a any type of.
There aren't any.
Right, you're absolutely right. But what I can tell you is that from the latest report by Mrs. De Bruin, it does seem to be that that the child is still adverse to engaging in deeper conversations, which Mr. Bruin comes to the conclusion that she believes the child should continue in therapy until they get closer to the root cause of her prior behavioral problems. Now, since they have went to this supervised parenting time over the last, 6 months or 5 months, the behavioral problems that the plaintiff has seen in the child have essentially abated. The child's no longer wetting the bed. The child's not lying. There's no more inappropriate YouTube watching. Her sleep schedule is back to normal. And this all may be a coincidence, and I'm not trying to paint Mr. Hernandez in any type of, I'm not trying to come to any conclusions whatsoever, Your Honor. I'm not trying to make him out to be a bad guy at all. What I'm saying is that the problems with the child seem to have abated, and what I would like to do is have at least some additional time so that the therapist could actually finally engage with the child and find out, why she was acting out, or, why some of these things happened. I realize we're all in a difficult situation because we can't get a professional to make any conclusory decision. We know that. But, my client's position was never to deprive the father of parenting time. It just simply was to get to the root of the problem, and until such time that they could and
I appreciate your position. I appreciate your honesty and everything. Okay, I'm just, the child's 9. We've deprived him basically for 6 months, if not a little bit more, because I think the order came out back in May or something like that. And we've, and I don't know if this therapist is ever going to get to the root problem, because I don't know how long this therapist has been working on it, and not going to make any recommendations to the court and all that kind of stuff too. And my suggestion is, why can't we start reintegrating? I'm not just going back to the same parenting time. I let some time pass, but why can't we start some type of parenting time, not at Journeys, because he's paying all the time, and Journeys is just, that's a stopgap. I mean, that's an artificial setting. You go in and you sit in a room and people watch you at everything you do, and it's artificial for both the father and for the child there. And my thought is to start, some kind of, instead of 1 hour at Journeys, we do 4 hours at the mall and the food court or something like that and see where things go. Because I'm just concerned that I'm going to keep waiting and waiting and waiting for a counselor who's never going to help me out anyhow. And I don't know if this counselor is ever going to get to the root cause or anything, but I'd like to see, because if we at least start something for the next 2 months or whatever, they can agree on a spot. You guys can agree on a spot. You can agree on McDonald's or Denny's or any kind of stuff. A couple hours where he's with the child, and if things start going good for those next couple of visits and stuff like that, we can start to increase it relatively rapidly. If things come off the rails, then we're going to have to, I don't know, go back to go. But I think that's what my thought is to start some kind of in the community at least a couple hours, 1 or 2 times a week or something. I don't know if they live near each other. Do they have any? Can you and Miss Maltby come up with some kind of a suggestion, like going to Chuck E. Cheese or going to she might be 9, maybe she still likes Chuck E. Cheese, McDonald's, Denny's, the mall, some of these things that are out in public right now. And obviously Mr. Hernandez, who we don't even know has caused any problems in the past, but certainly he's not going to cause problems while sitting in Denny's eating breakfast with his daughter, and see how things go. Come back in where are we? December, January, come back mid-February and see how things are going, and look at if things are going good. It's like you said, your client isn't asking to take him out of the child's life. She's got to be realistic too. And I mean, the daughter's not going to be, mom's got to tell her, dad wants to see you, and, we're just going to go there and drop you off and I'll be right back in 2 hours and pick you up. Do you think you guys, I don't want to order something. I don't know where they live. I don't know if it's, what would be something that would be appropriate for the child to go to or whatever. Do the two of you think you can come up with a location or locations that you can do this at least? I would say every Saturday or Sunday, and maybe even one evening for Wednesday for just a few hours, taking her out to dinner, that kind of stuff.
I think I can work with Miss Maltby. I'm certainly.
That's not what you talked about her when she was not on the screen. You said other things.
Always stirring the pot, Your Honor. I also believe I can, communicate with Mr. Christensen to determine, some sort of schedule to do. Yes, a midweek couple of hours that Mr. Hernandez can pick up the child and spend some time. A weekend, maybe, 3, 4, maybe larger chunk of time that they can do something in the community. And maybe the location will vary, from week to week. So they're not always doing the same thing, but I think that's something that we can talk about. So then we can regroup in a couple of months to determine what the appropriate next steps would be.
I want the clients to understand that if I have to, I'm going to order stuff and I'll pick a location and everything, because this is what I want to happen. Okay. But it makes it really inconvenient when I'm trying to tell you where the child should visit and that kind of stuff. It should be one evening for an hour, hour and a half, whatever, for go out to dinner or something like that. And on a weekend, a few hours, Saturday or Sunday, whatever works best. And I'm going to have your counsels, because they can talk to you guys and figure out what it is. Okay. But I don't want you to think that they're just going to kind of work stuff out. They have to work stuff out, because otherwise I'm going to work it out. And I'm really not good at that, because I don't know where you live or anything. Okay. And I really want it to be something that maybe you guys can agree on, that it'd be fun for your daughter and all this kind of stuff. And let's see how it goes. If things go terrible, somebody come back. You can renotice this, quite frankly, instead of making them pay the motion fee and stuff. You can renotice it, or just wait for a couple months and renotice it anyhow, and we'll take a look at it. However, if things are going really good, I'm headed back towards the same parenting time. And if we can do that, you guys can always agree on that too. I'm hoping that I know the attorneys are reasonable. I have to have the parents be reasonable also. All right.
Your Honor, briefly, just to help expedite the process, especially with the upcoming holidays, could we make a quick determination of something that can occur this weekend, just so we can get this going and Mr. Hernandez can have some time this week and, this upcoming week for a quick dinner. And then Mr. Christensen and I can work together, moving forward for the following weekends.
I don't see why we can't. I'd just as soon Mr. Hernandez not have to continue to visit at Journeys. Okay.
I agree.
Because I think it's like a $50 fee every time, and he sits in a little room with his daughter.
I agree. And so I'm just hopeful that
Whether it would start Saturday or Sunday, certainly we got to start it during this week, pick a spot, have some time. Next weekend is, Christmas is Monday. I want you to get him so that he sees his daughter, if nothing else, Christmas Eve or something like that. Maybe goes out to someplace fun, go see Santa. I don't know, go to the mall, do anything. That is my intent at this point. And I'm leaving it up to everybody to do that.
perfect. I will speak with Mr. Hernandez right after we log off, and then I will give Mr. Christensen a call and let him know what the proposed times and places are for the next couple of weeks.
Mr. Hernandez, do you understand what I'm saying?
Yes, I do.
All right.
I just want to add, I guess from now through February, whatever we come up with, I guess, how would I know the positive traction towards, or if it's negative?
The mother will no doubt contact her attorney, who will talk to your attorney.
Yep.
All right. That's the good part about you guys having attorneys. Ma'am, I forgot your current married name. I know it's a lot easier than than the other name, but you do understand what I'm requiring of you, don't you?
Yes, Your Honor.
All right. I want his daughter to start seeing him again, but we're gonna do this a little slow for right now. Okay.
Thank you.
And I do want him to see her at least some on Christmas Eve or Christmas. I mean, if the party's going to agree to it, that's fine, but do some time there. Okay. All right. I'm leaving it in your capable hands, counsel, and hope that I made a good choice.
Thank you, Your Honor.
All right. Good luck. You can submit an order if you come up with a date and time, the times and stuff like that. You guys can submit an order to the court for that. I'm obviously not. You can. I'd like an order sooner or later, but let's work on this. You may come back as soon as like 8 weeks to review this if all is going well. Good luck.
Thank you.
Have a great holiday season, everybody. Thank you.
Thank you, Your Honor.
Is this the last one? Before the last one? Okay. Both parties are present via Zoom. Ms. Van Tol is here representing the defendant, Mr. Sylvie. These are motions filed by the plaintiff mother. There are a couple of them, and I kind of try to deal with them in order. The first motion is really, says wants clarification of the order for exchanges when a child is sick. Is in essence what it is. Ms. Sylvie, that was your motion on the first one, is that correct?
That was the most recent one that I filed.
Yeah, I said that's the one, right?
Yes, sir.
All right. Anything you want to briefly add? I mean, I'm not going to micromanage this case, but I'll let you say something if you want. This would be like saying, well, if the child's got 103 temperature, does he go with his mom? If he's got sniffles, does he go with his mom? I'm just not going to micromanage this case. So what do you want? There are times that you're supposed to pick them up. If they are not there when they're supposed to be, you file a complaint with a friend of the court for parenting time violation.
Yes, sir. I just wanted clarification that when the kids are sick, that's what we should do. There was a lot of correspondence with the defendant. It just was causing a lot of extra stress and unnecessary issues. And then,
but I'm saying I'm not going to micromanage that. There are times, and if your child's sick, I assume you know it. And this is just stuff parents have to do. I'm not going to tell you if he has 102 temperature that he doesn't have to go, or what time it is. The order is the order.
Okay.
Ms. Van Tol, I don't know why you'd want to say anything on this, but you can if you want briefly.
I don't need to weigh in, Your Honor. Thank you.
All right. That was the first motion as I understand it. Was there anything else that you really wanted in that, ma'am?
In terms of sick.
That was just a
exchange-
request for a clear order to exchange when the minor child are sick or no school. We dealt with that one. And
Yes, sir.
that's out, okay. Then the second one is motion for to show cause and clarification. And this lists a whole bunch of things that you want me to go through. What specifically do you believe I need to show cause him on or find him in contempt of court? You listed stuff like parenting time, extracurricular activities, things like that, misuse of our family wizard, using other modes of communication like email, impersonating children on the cell phone or social media. I don't know how you know that. Taking pictures of you and speaking negatively about you. Those are some of the things you've asked for and to hold him in contempt for. Isn't that correct?
Yes, sir. There were 3 occasions. He showed up after school during my parenting time.
Did he interfere?
Yes, yes, Your Honor.
In what way?
He told minor children.
Your Honor, I'm gonna object to any hearsay.
I'm gonna let her just say stuff. I'm not necessarily whether it's true or not. He told the minor children, you're saying?
He told Jude not to get in the car with me or else he will be punished. The
It was
children
at a parenting time, you're saying, and he told him that, and Jude got in the car with you anyway, or what?
Yes, Jude got in the car with me. He was very upset. It affected, it's affecting his schoolwork. We have an order that we cannot be at school or extracurricular activities on the other's parenting time. He showed up 3 times after school at dismissal to pick up Jude when I've been picking him up from school for the last.
And I understand, Ms. Van Tol, didn't you say he was at the school, did not interfere? He was there to make sure that the children got picked up or something?
So, Your Honor, if you will recall, in my response, all I indicated was there was no clear definition of what pickup time would have been. Ultimately, what the court had indicated in the order was that it was an evening, it was an after school in the evening or as early as 3 p.m. So Jude ended up getting out of school before 3. We've had substantial issues with Miss Sylvie getting homework done. My client desired to not have Jude go straight to Miss Sylvie's house, so he was going to pick up. They had a whole OFW exchange related to this. It never got really resolved. All Miss Sylvie did was basically ignore what Mr. Sylvie was asking, which was, where in the order does it say you can pick up before 3? And who is picking up because you work after 3? And so she wouldn't respond to those. So yes, he did go to the school. He did not interfere. He didn't step out of his car.
What time was he there? What time was he there?
Like 2:40 when the school releases.
Okay.
And he did not interfere with parenting time. He didn't go by her car.
And so when was Miss Sylvie there also?
I believe on every occasion, I can't really recall, Your Honor. Again, these things have been happening since the beginning of the school year, but my client stopped going to the school after basically we just said, listen, if it's going to be after school, it's going to be after school. Fine. She needs to be responsible for homework. We brought that issue before Judge Hillary. So there was no interference at all. And the order that Miss Sylvie is referencing does not state what she indicates. It's the order that the judge had related to her attending extracurricular activities with the children. It has, my client was not violating that court order. I could read it into the record. It's not a violation.
All right. I don't really find that causes much problem. If she was there at 2:40, he was there at 2:40, not known for sure, didn't interfere. It's his testimony that he didn't interfere. The child went with the mother. End of story.
Yes, that's what happened.
Okay. Even though he talked to the children, talked to Jude.
Oh, good Lord, he talked to the children?
Well, the order states both parties. It's not just.
I'm telling you, he went there a couple times to make sure things went. He hasn't. When was the last time he was there?
Mr. Sylvie, can you report that?
Mr.
Your Honor, it would have been mid-September to late September. I don't remember when that would be. The order does not say anything about school.
So anyway.
But the pickup is at school. She's been picking him up at school. All's well that ends well, right?
That's what's happening. I don't know that it's going well, but yes, that's what's happening.
What's your next one, ma'am?
Mr. Sylvie sent me a text message from our son's phone as he was Jude, our son, telling me that I need to wear a whole shirt when I pick them up for exchanges.
Did you? What exhibit is that?
That is.
Did you do that, Mr. Sylvie?
Your Honor,
Not he describes.
I'm sorry, Your Honor, that was exhibit 12.
Exhibit 12. Look at this from Matt on 9/29. Hey, Jude Bug, look at this. It's finally done. I've read all these things ad nauseum. Can you show your brother too? Oh man, we aren't friends on Snapchat anymore.
That was from the defendant. And then the following one was from the defendant.
Put on a whole shirt when you pick us up at school exchanges as we are in public. Sir, did you use that phone and make those? Or Miss Van Tol, did he do that?
Thank you. Yes, thank you, Your Honor. So my client did send those messages, Your Honor. The issue really is, this has been a longstanding problem. Mr. Sylvie purchased a cell phone for Jude. Jude.
I'm going to interject. That has nothing to do with
Don't interrupt her. She did not interrupt you. Go.
I just want you to have the history here because this is why it's relevant.
I have so much history.
Judge, I understand. I don't want to be here either. I understand where you're coming from. But so the cell phone my client bought for Jude was going back and forth. Mom said, Jude's not allowed to bring this cell phone to my house anymore. Then my client said, well, then don't contact him on it. She had purchased a cell phone for Jude. My client said, don't bring it to my house. If that's what we're going to do, then the kids are going to have different cell phones at different residences. So what happened was, she was continuously contacting Jude, as you can see in the exhibits, on this cell phone. My client found it when he was looking through stuff. He did message her so that she would know that he knew. There was no way that she would think that was Jude. My client really wasn't attempting to be Jude. He was trying to let her know that was happening. Obviously, as we go through this, you'll see that Sina has been working with Jude to hide the cell phone from her house and his home so she can continue to communicate with him after he's supposed to be in bed, causing him to do poorly in school. This is just a cycle of constant
he's
stuff.
asked for is the return of the phone, which I don't know why I'd return a phone that he's not even supposed to have over there in the first place.
Well, honestly, my client had no idea where this came from. The first note that he knew that this was Sina's cell phone was through this motion. She never asked him saying, hey, this is the cell phone for my house that Jude is using here. My client looked at that cell phone. Your Honor, I should let the court know there is no parental controls on there. He does have it. If the court's going to order that he provide it to Miss Sylvie, then it needs to not ever come back to his home. It's not to be in his house. He can't monitor it.
I'll go to this point right now, ma'am. You provided a cell phone to Jude?
Yes. And that's
and you sent it to his house?
No. It's
How did it get there?
It's Jude's phone. Jude knows that if he's going to take that, which he just started taking that in September, October. This is a different cell phone though. The message is,
you provided it to him and then you've got him hiding it at Dad's house.
No, Your Honor, that is not true. Jude is responsible. We had a conversation. If he was going to take that phone, he needed to talk to Dad about it. I am not responsible for a conversation that he chose not to have. I never told him to hide the phone. That's not appropriate. I would not do that.
Why would you give him a phone when he has a phone that Mr. Sylvie had provided?
So the phone is for my parenting time. So I agree with what Ms. Van Tol says. If there is a cell phone, we should both have access to parental controls. In February of this past year, Matt would not allow me to have access to the phone from his house. So if Jude brings a phone from the defendant's house or from Matt's house to my parenting time, I should also have access to see like what apps he has, if it's my parenting time.
I'm lost here and maybe it's me, but if Mr. Sylvie provides a phone to Jude and he brings it to your house, which he does, and then you prohibited him from taking it there anymore.
Yes.
Why would you do that?
Because if it's my parenting time, I should have access to parental controls and to see what apps he has access to.
He's got the phone with him. Why can't you say, can I see your phone for a minute?
I don't know. I guess.
Why can't you ask your, I mean, it's like, it's not kept away from you. You know, he's got a phone. What parent doesn't just say, hey, let me see your phone. I had kids, you know, they don't own the phone, but instead you prohibit him from bringing it.
Yes, there's also been text messages from Matt to Jude that have interfered with like family functions, and the way that they communicate, it impacts Jude. So if they're communicating in a negative way,
That you don't want him to have the phone then.
no. If I don't have access to
You're
any
talking
phone,
in circles because you got access to the phone when Jude has the phone at your house, even though it's provided by Mr. Sylvie. You can take it away from him if you want. You can look at it if you want. Instead, you prohibited him from bringing it, so that I don't understand why. This is just bizarre to me of why he wouldn't. So instead you say you can't bring it anymore. I'm going to give you a phone that you can have. And apparently he was hiding it from Mr. Sylvie. I don't, and you were talking to him at all hours of the night.
so we don't text on that phone. Jude will find any way to communicate with me. It doesn't have to be with a cell phone. Like he communicates with his friends on other apps that he has access to.
I don't, this just doesn't make any sense to me. Because he had a cell phone that he could have used. One cell phone he could have used back and forth until you prohibited him from doing it.
Right. But if I don't have the same access to controls or location, it's not equitable.
You have access to controls and location when he's at your house. He's not, you got it there. You can take it from him. Mr. Sylvie has access and control when he's with him. Right?
Yes.
You're talking in circles here. He should have one phone that he could have used, but then you got to the point because you didn't, I don't know what. I don't know what you didn't like about it. You didn't want him bringing it there. Isn't that correct, Ms. Van Tol?
That's correct, Your Honor. She had kept accusing Mr. Sylvie of spying on her, and that was not the case. It is just, this whole thing is just.
I don't even know how he spies on you because dude's got a phone.
He doesn't. It's just paranoia.
Well, I'm asking Ms. Sylvie. I don't even understand it. Jude's got the phone.
Yes, Jude has the phone. If I don't have parental control or access to anything on the phone, but Mr. Sylvie does, that's not equitable.
Why don't you have any parental controls when he's at your house? You can literally take it from Jude and as punishment if you want or something. Why is it that you think and so then you decide you're going to have something and send it with him? This is crazy.
Your Honor, I never sent the phone with Jude. I am not responsible for a 14-year-old. And what he takes.
Did he leave the house with the phone?
Yes, I can't check his pockets. It's not reasonable. And also
Aren't you his parent?
I say to him, if you take the phone, you have to have a conversation with
Did
Dad.
you ask him when he left, are you taking the phone?
No.
And why not? You're not the parent?
I'm not.
And this is absolute garbage. Garbage. He leaves, he goes, and you say, gee, I don't know whether or not he's got the phone or not. I don't care what he does and that kind of stuff. You know, he talks to you from his house on the phone. So how do you not know that he's got the phone?
Your Honor, because he doesn't use the phone to text or if we communicate. He could use the Xbox or a different application on his computer. Your Honor, I told him if he takes the phone, he has to have a conversation. He didn't take the phone when I got it for him back in March. That did not start happening until September.
Ms. Van Tol, anything you want to add on this?
Your Honor, I just think it is completely ridiculous that she has knowingly allowed this child to have the phone at my client's house, knowing that she said my client can have Jude can't have his cell phone from my client's house at her house. It's just bizarre. I don't understand it. All she's trying to do is create conflict. It seems to me like she is working with Jude. Jude's not a messenger here. If Sina knows that Jude's bringing that cell phone to Matt's house, it is her job to tell Matt that because they've already had this conversation where she said Matt's cell phone couldn't be at her house and Matt said then vice versa. If you're going to get him a cell phone, it's not going to be at my house. She knew that conversation happened. Jude's not the messenger. She was responsible for making sure Matt knew that cell phone was in his house so that he could do what a parent should and monitor the use.
Absolutely. Just like if the phone was going to her house and Matt had given it to him, she could monitor that phone.
100%, but Matt didn't know the cell phone was there, so he had no idea what was going on, and that is inappropriate. And it puts him and Jude in a position to have conflict, and it is seen as gold to have this happen.
Absolutely. And ma'am, you're giving up just saying, well, I didn't know. You know, you're communicating with him. You know he had it. You know you bought it for him. You know that he was taking it there because he didn't leave it obviously at home. You didn't go so far as to say, are you taking it? Because I don't know, you don't feel that that's your responsibility, and it is. End of story. That is again something that I don't know what I don't know what to do. But you want this cell phone back, ma'am? Is that what you're saying?
That would be nice for my parenting time so that I have access to the kids.
For your parenting time? Well, it would be nice if there was one cell phone.
I agree.
And it can be Mr. Sylvie allows Jude to have his phone and sends it back and forth. Because I don't know why that can't happen. If there's no reason for it. Can you give me any reason why Jude should not have one cell phone?
Yes, Your Honor. Okay, no. I do not have a reason.
Ms. Van Tol, you believe Jude should have one cell phone and it can go back and forth with him?
I think that was the goal originally. I don't know what Mr. Sylvie's position is now. He definitely doesn't want her taking parental controls off the phone. So if she's going to be on it, I know
understood, but she doesn't have him that long that so when he comes home, he can check and see that the parental controls are still on.
That's true. He can do that. Matt, are you
And
good
if, if he finds out that she's taking all parental controls off, I'm sure he will inform you, and that won't go good because there needs to be parental controls on every kid's phone.
That's correct. Yes. Okay. And Matt's fine with that. That's fine. That's what was the goal in the first place. I'm really not sure why there's two, obviously.
So what do we do with the second one? It should be not in Jude's control at any point. Should be shut off. Shut it off.
I would like an order saying that is not to go to my client's house again. This cell phone, it's again, it was secretively being done. I'm not really sure.
It is not to go to your client's house, and both, ma'am, you're going to be responsible and make sure it doesn't.
All right, I understand. I would like to address that I am blocked from that phone. So if that phone does come to my house, my number needs to be unblocked so that I can reach the children or Jude on my parenting time.
That's absolutely fine, Your Honor. That is absolutely reasonable.
All right. There's an agreement right there. The one phone should have access to everybody. All right. Settled that. What else do we need?
We didn't settle that text message that was sent to me from Jude's phone from Matt's house.
What do you want for that?
That's not appropriate.
What do you want?
I
don't do that ever again, Mr. Sylvie, because now you only have one phone that's going to go back and forth. And if you contact her on Jude's phone, you better make sure that she knows it's you. There you go.
So the point, and also any social media apps. There's another message that that Matt used as Jude that he sent to me. So the phone and any apps that belong to Jude.
Ms. Van,
he did not try to indicate that he was Jude on that app, but that's fine. At the end of the day, again, it was because she was communicating. She knew that she wasn't supposed to be. And ultimately, again, we understand it won't happen again. It'll be an OFW message if we need to.
You can put that in the order, Ms. Van Dole.
Yep.
What else you want?
That Matt stopped taking pictures of what I'm wearing and telling the children that it's his job to report to the authorities how I dress, and that is not appropriate.
His job to report to the authorities?
Yes, so that I need to be held accountable for how I dress.
Yes. All right, Miss Van Tol, what's this?
It never happened. Here's a huge problem. So on October 13th, I believe it was the date, Miss Sylvie picked up the kids. My client records as usual because he doesn't trust Miss Sylvie at all. As Jude was getting out of the car, he saw my client recording her. Now he has dash cam, so this will never happen again. This is the way that we've resolved this issue. And Cena made a whole scene about it, created an entire false scenario about what happened, claimed that my client was chasing her or trying to like approach her. That never happened. They were at a location where there's no cameras. My client tried to get video. They didn't have it, whatever. In any event, she then takes the kids to the police station, has Jude report falsely to the police officers what a statement my client made that he never made. And then she goes and files a false PPO on these same allegations that gets denied by the court. She claims in the police report, I know the court doesn't have it, but that my client had sent her a message at the time she was at the police station about her attire. Never happened. You will not find a single message related to that to Cena on that date at all. And so all of this is lies. She files the false police report. She involves the kid in it. Jude, obviously, Noah is not as manipulated as Jude. Unfortunately, Cena's really got her claws into Jude, unfortunately. But she used Jude to make a false statement to the police. And that's what she's relying on to continuously report false statements to this court. It never happened. That did not happen. And it will never happen again. And Cena won't be able to claim it because now we have dash cameras and we are taking all of our exchanges at the public museum where there's a camera. So this will never occur again. So Cena cannot make these comments ever again.
All right.
Your Honor,
Yes.
these things happened. The children were upset. The children asked me, you're not going to believe me. The children asked Matt why he's always taking pictures of me. And that
the children asked Matt. You weren't there.
I know, but the kids told me that he takes pictures of how I dress, but then I get that message. It just confirms that he's taking pictures of my body. He's talking about me and my body to the kids. It's not appropriate. We're raising boys. I cannot make these things up, Your Honor.
And you can make them up, and you've made up a lot of stuff to the court in the past.
I know, but things changed in August. I have no reason. I just want Matt to be held to the same standard that I am.
Matt has gone so out of the way because of all the difficulties that have clearly occurred. I can go all the way to the beginning when the judgment of divorce was there, and you were supposed to provide items to Matt, and they were damaged by you when you sent them out there. We ended up not having a hearing. I can go all the way back when you said, no, I didn't damage them, but it was clear you had, all the way to the hearings that we've had and whatnot. And I don't know how you expect me to just forget everything that's going on, as well as with Judge Hillary. I've talked to Judge Hillary too. I mean, we both had this case over and over and over again. I don't know that Matt is taking pictures of you for some unknown reason, other than at parenting time exchanges, because everything is such a mess. Things do not occur the way adults should have them. All right. Just like you asking for, I got to figure out what to do if a child is sick or something, and I can't tell you how. Yes, you can make stuff up. You have made stuff up. You made stuff up to me. You made stuff up in the trial, significant stuff. You did stuff that was over and above decency with him. You lost custody because of it. Then I understand you just lost legal custody. You can come back maybe, but this doesn't show that you guys are going to ever get along. This is obviously a negative towards you ever getting legal custody. And some of these things like the phone and stuff that are just outrageous. They're outrageous to the point where you can't even justify them. And I don't understand what you think. I really don't. He needs to get a dash cam to prevent things happening, and needs to do that at a location where there are cameras and everything. And I do believe he needs it. And he's going to pay for all that because he needs it, because you are always trying to push the envelope.
Your Honor, I understand. I understand what you're saying. I am not making up excuses. It's all there in OFW the way that we communicate, it's not working. The issue
You guys should hardly ever communicate. You guys should hardly ever communicate. You got 2 kids. He's got the time with them most of the time, and he doesn't, and he has legal custody and everything like that. But you're always communicating, and it's you as much as him communicating. Many times, you're sending him stuff, and he's answering it, and all this kind of stuff. I don't know how to stop. I don't know how to stop it. I don't find. I mean, I don't know how else to say it other than there have been so many things that you have accused them of and done in the past, and I think Mr. Sylvie has had his fill of it and is starting to fight back, and maybe not always completely appropriate, but I understand why. And I mean, just like coming in, I don't know what you want. He has to follow the court order. You have to follow the court order. If there's problems with parenting time, you file a complaint with a friend of the court. They'll investigate it. If there's a possibility that there is a violation, it'll end up in front of me on a contempt of court hearing. As far as some of this other stuff, I am very concerned of you using Jude to try and get some things you want. And I have a tendency to believe Mr. Sylvie more than you when it comes to, yeah, you're talking to him all night and this kind of stuff. And I'm not even, I kind of think you probably had that phone for him, knew it was there and knew that you were using it late at night and stuff like that. That's my opinion just from years on this case.
Right. Thank you. I just wanted to make sure that I document these things.
Well, you can document, you documented other false stuff. You document them by saying what? You went to the police station. I don't know if that ever occurred. I don't see a police report or anything like that. You can go to the police and say, he chased me because he took 2 steps in your direction and make up something that's really big. There was something in here that bothered me in your motion when you said something in one of them. You start out with something about sexual things and stuff like that, completely irrelevant, just your desire to whack Mr. Sylvie if you can. It's clear that you will do anything to get at Mr. Sylvie. And that makes, when you ask for a PPO, people take a second look, because it is clear that you will do anything to get at him. No matter what. You go to the police and say, he chased me. Do you have any evidence of that? No. Just your word. I don't know what else to tell you. What else do you want the court to look at? Oh, I will tell you one thing. I know one thing you asked for, and I think it's appropriate. You asked for some medical insurance information for the kids. Correct?
Yes, sir.
Van Toll, the bottom line is that the kids are covered by dad, and I understand that he has sole legal, but there is the possibility that the kids could get suddenly injured in her care and she takes them somewhere right away for it. I don't know why she wouldn't have a medical card for the kids. She does have time with the kids.
I don't know what Mr. Sylvie wanted to report, but I would indicate that we're just worried about her violating the court orders. Again, taking him to providers she should not be taking him to. She obviously hasn't followed a court order.
Well,
really.
I'll tell you right now, she doesn't have legal custody, so she can't be just setting up appointments with the kids. All it would be for is emergency.
No, I understand that. I want Miss Sylvie to understand that and not violate it.
So, and you can put that in the order, because I don't think Mr. Sylvie, it's just as a backup, is she does have the kids on a weekend and stuff like this. If they were to be injured and she took them in, she might not be able to get in touch with you. I'm not saying you're sitting there watching your phone every minute of every day. You could be taking a shower or something. She takes them in. It would be nice for her to have medical information for the kids, but she cannot use it for setting up appointments, things like that, because she doesn't have legal custody.
May I say something, Your Honor?
Yes, you may.
I asked several times through that chain of emails, just why did she need it? I didn't say she couldn't have it. I just wanted to know why.
I understand, and
I don't mind giving it to her, but that was the very thing. I don't have any idea. If I send the kids to grandparents for the weekend, I don't give them medical insurance and stuff like that.
That's right.
It was just a point of, why would you need it? Just let me know. And there was always just a roadblock, a wall in front of it saying, because I want it. It's my legal right to have it, that sort of thing. I just wanted to know why.
Miss Sylvie or Mr. So I'm to the third one here, Miss Van Tol.
Yes.
Do you see any reason? I mean, I understand that. I mean, if you send the kids to the neighbor's house and something happens, they don't have the medical information. But the bottom line is, Miss Sylvie does have regular parenting time and is a parent. Okay, I'm not asking you to give the grandparents and stuff. I just think it's appropriate. Can you think of any reason, Miss Van Tol, not to give a card? But you can put in the order, it is not to be used for anything other than emergencies. I do not, ma'am, you do not have legal custody. You cannot make appointments for kids for orthodontics or for, you can't sign them up for extracurricular activities. You can't do that. You do not have that ability at this time. The only thing is for an emergency, the odds of you ever using that card are just about zero. But I don't have a problem in case something happens while on your watch. And you can believe me when I say, if something happens on your watch and you are abusing the situation somehow, it will not go good for you.
I understand.
I hope so. Mr. or Miss Van Tol, you want to put that in?
Yeah, so I will indicate cell phones to be returned, it's not to go to the client's house. There's no communication as the kids on any apps or texting. No extracurricular activities. She can't sign up for extracurricular activities. He'll give her the health insurance card, but she can't change providers. She can't set up appointments. She can't start new providers, and it's for emergency and urgency care only.
No, I mean, I suppose she could go to her work and try and set up some providers if she wanted, but Mr. Sylvie doesn't have to follow them at all.
Well, right. She's not allowed to just take them to, this is what we foresee, right? Miss Sylvie
Not allowed to
saying,
take them to you know, hey, I want you to go to this doctor and I want you to take a look at him for all this kind of stuff and that.
Yes.
You know, and see if he's abusing them and stuff like that. No. And if that comes up like that, that will be, I will stop your parenting time and give you 1 hour a week at Journeys, which is not real far away. All right. If I find out anything like that, you know, if you come in here and say, well, Jude came and told me that his dad beat him, and so I took him to emergency to do this kind of stuff, and if there's not something that is really right out in front, I will probably reduce your parenting time to Journeys 1 hour a week supervised. And Miss Van Tol can always get a copy of this on the record and beat me with it if it happens. Anything else, ma'am?
Your Honor, I do have a question about, Matt has concerns about me impacting his relationship with the kids. It's my understanding that they have been pulled from counseling. We had an order.
He's got full legal.
Okay. All right. I just want to make it aware that
You can, if you want to file some kind of a motion to get him in counseling, you can, but I'm going to probably say he's got full legal.
Okay, we did have an order that said if there were any changes made to counseling, that there would be a motion filed to have them taken out of counseling.
Is specifically referring to?
Yeah, it was prior to her losing joint legal custody, Your Honor, and ultimately there was no benefit to counseling because Jude wasn't talking to the counselor. So my client made this decision for a reason, and it was with the counselor's assessment. So again, it was after she lost legal custody that he made this modification. He had talked to the provider. It wasn't benefiting anybody because Jude wasn't opening up related to the issues, is my understanding, and Noah's doing well. So he's not needing counseling at all.
All right. Anything else?
No,
I'd
sir.
like to get rid of it all right now because
I asked for fees, Your Honor, for having to be here today again on these long motions that are rambling. And for the most part, she did not come up with a single contempt issue. She was just ranting. And again, all she's trying to do is file these pleadings with the court to disparage Matt in a public file as much as possible and to provide her false narrative as much as possible. This is becoming very daunting. Matt has had to be hyper vigilant in all ways because of these continuous allegations and these motions. And he's the only one with an attorney right now, and he has to continue to keep fighting this and defending this with Miss Sylvie. And again, there's are largely false statements, and they just need to stop. And I don't know how else to deter him for doing it.
Well, I'll tell you, they do need to stop. This, any legitimate claim can be filed, but if I'm probably not going to order it this time, but I'm going to tell you this: any more files like this that come up that you don't have something really significant for me to rule on, I'm going to order actual attorney's fees for it. I'm telling you that this is. Yes, I've heard this stuff for so long and so many times, and so many of them are false, and all of this. This was your one shot to go after Matt to prove that he was an awful guy again. It didn't work. I'm not going to listen to these anymore. I'm just not. But if you have something that is legitimate, like I'm going to use the example of some part in here I read, because he had told Jude he was going to have to walk to school in the rain. Okay. He's the dad. All right. You're not going to micromanage his parenting time with Jude. If he is something way off base and is doing something really detrimental, that's one thing. But dad saying, you know, yeah, if you're not going to get up, you're going to walk to school. You know what? I'd do the same thing. And I don't care what you're going to say to me. You're becoming a helicopter mom to try and say, oh, your dad's doing the wrong thing. Oh, poor you. I'm going to do this. Not going to work, ma'am. It's not going to work. I'm telling you. He's the dad. You've managed to lose physical and legal custody in a couple of years here. Something that very few people have ever done. And yeah, you're not going to micromanage dad's things that he does, that he grounds them, that he takes a phone, that he does this, that he does that. You've lost that ability. So, Ms. Van Tol, I understand your request, but you can. I'm not going to do it this time, but further things are either going to have really significant evidence, or I'm going to give you actual attorney's fees. So if there are other motions, you got to keep absolute track of time and stuff like that, because I'll give you actual attorney's fees as long as they're reasonable.
Sounds good.
Mm-hmm.
As long as they abide by the court rules and stuff like that.
And they do. I appreciate that. Thank you.
All right. Anything else from either party?
No, Your Honor, I appreciate the court's time this morning. Thank you for hearing it out.
Ms. Sylvie, anything else?
No, but thank you for listening today.
Good luck, everybody. Thank you. Have a nice holiday.
Have a great holiday. Thank you.
Hold on, before I go to one, I'm gonna go.